Motorists who were driving whilst impaired by drugs used to face a charge of driving whilst unfit under Section 4 of the Road Traffic Act. This offence often proved difficult for the prosecution as they had to prove that driver was not only impaired but also that this impairment was caused by the presence of drugs. But there was never any set limits in the way there has always been with alcohol. To make convictions for this offence a little easier, and in an effort to clamp down on driving whilst impaired by drugs, a new drug driving offence came into force on the 2nd of March 2015. It is now illegal to drive if either you're unfit to do so because you've taken illegal or legal drugs, or you have certain levels of illegal drugs in your blood, even if they haven't affected your driving. A comprehensive list of legal and illegal drugs covered by this legislation can be found on our website. Unlike the old impairment law, the new legislation does actually provide a possible medical defence if you're taking the medication in accordance with all instructions given and provided that you are not impaired. To summarise, you can drive after taking a legal drug if you have been prescribed them by a doctor, pharmacist or healthcare professional and strictly adhere to the advice on how to take them, and they aren't causing you to be unfit to drive, even if you are above the specified limits shown on our website. You can also be prosecuted if you drive with certain levels of legal drugs in your body if you haven't been prescribed them. The penalties imposed for those found guilty of drug driving are very similar to those of drink driving and failing to provide a specimen, as you will face a mandatory disqualification of at least 12 months. In more serious cases, you could face up to 6 months in prison. If you were stopped and the officer thinks that you were unfit to drive because of drugs, or an illegal drug is found after taking a roadside test, you will be arrested and ultimately be required to provide a sample of blood or urine at the police station for further analysis. If the analysis of your blood confirms the presence of drugs, then you may be charged. If the drug is a prescription drug, then you should only be charged if there is evidence of impairment. If the drug is illegal, then you will be charged regardless of your standard of driving. There are various ways that these cases can be defended, so if you have been charged or you think you may be charged having provided a blood or urine sample, then we would urge you to contact us immediately so we can discuss your case in more detail.